long story short, you all can look into it yourself. Incident to arrest. The suspect was searched. And McNulty, I apologize. I didn't speak to this to you about this yet. I haven't had a chance to. So if you want to talk about it after, we can have a chat.
Sure.
A suspect was searched. Incident to arrest was found with a notebook with some very interesting information on it. Some of it may be incriminating. Some of it may not be. Either way, the legitimacy of or the validity of us being able to read a notebook that's found on a person and read the contents of it just due to the search incident to arrest was contested today. Not officially, unofficially, it was contested between myself and Chief Justice and the
Rami,
a lawyer. Now, it goes down an interesting path of digital versus paper, of search incident to arrest, what can and can't be searched. If we should be searching the book for weapons, for drugs, or any sort of contraband that could be introduced through that book, that's all up in the air right now, and on what grounds. I'm just going to be completely straightforward. I didn't have a really good a good way to defend it, other than the fact that it's search incident to arrest and it's presented there in front of us. And I guess there's a lot of what ifs, what about, and possibilities, such as what if we read, as we're searching it for weapons, something about weed, where now we have an idea that it might have some incriminating evidence on it. There was a lot of things that went back and forth. Ultimately, I just want to keep you guys up to date on this. We're going to hear back about it soon, quote unquote soon, from the Chief Justice as to how that's to proceed, or if it's to go to some sort of a trial, if they want to try to suppress it, if they want to try to.
I mean, whenever you get arrested, you're subject to search and
search,
seizure, right?
The Chief Justice said it's
the question is
arrest, but then reading it, I just want to keep you all in the loop on it. I know there's probably a lot of questions about it, and I probably don't have all the answers for it.
Or is it like a phone and you need to actually, have personal probable cause tied to that item?
Any questions?
It's a very interesting conversation, honestly, and because it brings in what you said, digital versus paper. But I mean, Cletus, you're talking?
Oh wait, what was I?
Yeah.
Oh, shit, I'm sorry.
Oh, I mean, if you have something to say it. It's fine.
No, sorry, I just probably had something in my throat and I didn't realize.
All right.
Oh, like I was saying, it just brings in the question: is it gonna be treated like a phone, where you need to actually have probable cause or a subpoena to get the information inside of it, or is it where it's subject to search and seizure, to where whenever you get arrested, we can open it up and see what's inside of it, and that has to be documented. So we'll see how it goes. We'll keep y'all updated, but it's definitely an interesting conversation for sure.
So just want to keep you all filled in. Like I said, McNulty, if you want to talk more about it, I could try to fill you in after, if you're interested. All right. However, the Chief Justice did say, even if there is something put in place that prevents this from happening in the future, that it would not apply to this situation, since it's already done prior to it. They'd have to actually contest more than just the ability to do so to get rid of that evidence. So moving on, though,